welcome to our podcast. And my name is Muhammad Mus'ab, and
I'm Bruno Asago, but you can call me Said.
And we wanita ini lagi bersama.
I'm Putri.
And I'm Diana.
And today's video, we're going to talk about Article 12, Equality or Privilege.
Yes, sir. Okay, so before we start with anything, of course, we kena ada introduction dulu kan. So, what is Article 12? I would like to start first with what is Article 12. So, Article 12 is basically it's in the Constitution of Malaysia. It guarantees equality for the person who's about to get education. And in terms of like public education so they have fair rights no matter what race, what religion, what gender you are. Everyone is supposed to have equal public access towards the education. It says in the Article 12 here that without prejudice, there will be no discrimination against citizens against religion, race, and place of birth. So basically, everyone has the same right. Everyone should have the same right for education. So, what about you guys?
So like on the Article 12, okay, so in the article yang you baca tadi, Article 12 Clause 1, basically like dalam bahasa mudahnya it's like dia nak cakap about like the government cannot treat you unfairly, right? In education just because of your religions, your race, your keturunan, and where you were born. So I think my opinion that the reason they have this article is because this article needed to be applied to the public school, universities, in the terms of student to not pay the fees and student to not receive the scholarship and any loans or financial aid from the public funds. So the rest of that, I personally think juga yang Article 12 ni, the purpose is really crucial untuk someone to get their future, right? To someone create their own future and also to expand their social mobility. So what about you guys? Apa yang korang rasa, what is the important of this Article 12? Okay. What do you think? Apa kepentingan Article 12 ni?
For my opinion, kepentingan dalam Article 12 ni is about education for all the new generations. So basically, this article is to prevent from this discrimination, like how do you say, macam pilih kasih between the student and the teacher. So it's really like a pretty good like article for the world, so that they can like.
You mean the right article to protect them?
Yeah, the right article to protect them from like discrimination, and that to provide them the bright future. So because like diorang pun mesti ada like different ways, like different way nak pergi nak, like for example this student A and student B, student B want to go to be doctor, but student A want to be the article. So basically, tapi they both have to learn the same subject in the high school, like for example science student. So basically the teacher have to like ajar sama rata between them, so supaya mereka boleh like mencapai cita-cita tertentu.
So you're saying like apa, no matter like what they're gonna chase in the future, the basics is still teach the same, no matter apa dia pick science stream, okay? So okay. So what do you guys want to add to this, or you guys want to add to this point?
I think we just go through the other part.
Okay. So so do you guys agree that the purpose of Article 12 is to recognize education as a fundamental right? Do you guys agree about that?
How about you want to answer that?
Do you agree that education is a fundamental right? Like it's essential for societal development for for the future generation lah, or like for the students to develop the country itself. Is it a fundamental right?
It is fundamental.
Yeah.
It's literally stated in the fundamental rights part 2 in the Federal Constitution, because everyone kena receive education fairly, equally, because education is what yang help you to get your future, right?
Yeah.
So that's why it was stated in the fundamental liberties part 2 in the Federal Constitution. It also apa yang I baca that Article 12 ni pun really important as a safeguard. Maksudnya dia safeguard as like macam nak elak from any discrimination, because it also to make sure that government ni don't use the power for the power yang diorang ada to over education, or to cara kata to give a over education to a particular punya group. Like orang yang kaya ke, orang yang biasa ke, B40, M40, yeah.
So basically to prevent like unjust exclusion lah of like the other.
It
Okay, so
sounds like fair, but it's actually the education should be the equal for everyone. For me lah.
What is the legal effect of Article 12? So I would like to add first that one of the legal effect that Article 12 has on Malaysia is government policies, laws, and decisions relating to public education. It has to comply with Article 12 sebab dia memang dia punya core of our education. So without Article 12 ni, we can't really
balance.
Yeah, you can't really balance. And also Article 12 is justifiable. Yeah. So what do you guys think is the legal effect of Article 12?
I think the legal effect in the Article 12, it binds to the public authority. That means like government school ke, public universities, ministries, and anybody yang using the public funds for education. It's what we call the negative right, because it stops the government from discriminating, and it doesn't force the government to provide free education at all levels. So as an example, like Article 12, it doesn't guarantee you in place university. It only guarantees that if a place is available, you won't be denied it because of your race or religions.
So you mean like if the institution macam mana ya nak kata, okay, if that student dia sponsor ataupun ditaja oleh kerajaan or scholarship, they cannot discriminate based on their religion, race, and
in terms of yang artikel tu dah state tadi lah, keturunan, apa lagi,
perkauman,
religion, agama, race, place of birth, yeah. They cannot discriminate that in the terms of you nak go for the fund in the public authorities ke, yeah.
I see.
So we all can agree on the same legal effect lah. It's basically to any school, any public, private should follow like it should comply, it should be fair, that everyone could get the same treatment in the university and not exclude any race, any. So that's what we agree on the legal effect. Okay, so now I want to move on to the limitations and exceptions. So I would like to add on the limitation and exception as well, which is the Malays, especially Malays, would have more rights in terms of education, especially Bumi Putra lah, yang Bumi Putra, sebab certain universities, public universities, saya nak UiTM UiTM only Malay saja, and it causes an issue lah where other races
Races.
Yang bukan Malay lah.
yang bukan Malay, other races lah, the
They are
Chinese,
complaining about
Indians,
that.
they complain, they're like, why don't we have the same rights? But we're all Malaysians, but why do only the Malays get the rights? So I guess like this is the exception for tu lah. And also scholarships as well. Scholarships. Some universities only offer Bumi Putra scholarships, even though they might accept other races,
But
they only give the scholarships to the Malays. So
Yeah.
it causes like this tension in between races.
Yeah.
So
Can I add?
yeah, sure.
Yeah, because like for like this keistimewaan orang Melayu, basically it's under article like 152 to protect the keistimewaan orang Melayu. So basically when like the Chinese people or Indian people like complain like, oh, why Melayu dapat lebih hak keistimewaan, but literally benda tu dah diletak dalam law, akta lagi daripada dulu, sejak merdeka lagi dia letak benda tu. So basically there's no like tak ada benda yang
So they have no rights to complain about that.
complain about that, because it's really on the akta, dah kata dah, it's already put in there.
Would you mind I correct you? Because
Okay.
based on
okay,
what
okay.
I've searched
It's
on
my
my
opinion, it's my
research,
opinion.
the one that you said about the Malays have the special position is actually on the article 152.
Yeah, 152.
153, sorry. Because 152, it was said that Bahasa Malaysia as national language. But 153, sorry,
okay.
correction.
Yeah,
So
correction.
153 yang they provide special positions for Malays and native Sabah and Sarawak, which can also influence the quotas and privilege in public education and scholarship, like what just Musab said, right? So that's why kita boleh nampak like UiTM mana ada macam student in Indian or Chinese.
It's only
That's why
Malay.
most of them are go to the international,
like, for example,
swasta lah.
Yeah.
Swasta.
Okay, I want to ask a bit of a heated question as about, okay, we know that this is an exception. Okay, we know this is an exception. But I want to ask, do you guys think that this exception is fair? Or do you guys think that this exception is unfair and memang tak cannot have? What do you guys think about it?
I think for me it's fair, because like if you look into the history, basically before like we have Chinese or Indian, basically it's Melayu already, like situ. Cause ni tanah Melayu ni already like most of it is Melayu lah. So basically it's taken by the British and Chinese and then Japan's. So basically it's fair lah for orang Melayu untuk dapat keistimewaan.
Chinese, you mean Portuguese? you mean Portuguese, not Chinese.
No,
Chinese tak datang lagi sini.
Alright, so can I add a bit more?
Yeah, okay.
Alright, so basically it's fair for me. It's about we go back to article 153, which is about the establish the Bahasa Melayu as the national language, and which is the effect that the medium of instruction of no, there was one.
There's 152.
152.
Oh, that benda.
I wanted to correct you on it, but it's fine.
I realised cepat, sorry. Alright, so based on article 153, like provide the special position, which is the hak keistimewaan orang Melayu and the native of Sabah and Sarawak, which is that Putri mentioned already about the quota so on. So
betul lah dia fair.
Yes.
Because it's what yang dah state on the federal constitution.
Yeah.
So why we need to have the opinion that it's not fair? Because that's what the
Constitution says. Why you need to challenge it?
Yeah.
Kalau kita like
You
if
cannot void that, you know.
If you question it, you're basically fighting what the federal constitution already says, which is the highest form of the law, by the way, the highest form of the law in Malaysia. So you're questioning something that's already dah kukuh dalam Malaysia. That's something that's already been decided.
We as a rakyat, we can have our own opinion, but we
cannot
also have the
we
limit.
cannot challenge it.
Yeah.
We does not have that macam power to do that.
But as Musa mentioned already about why we need to challenge that. Okay, if they still complain about the hak keistimewaan orang Melayu, so how about the sekolah kebangsaan yang berjenis, which is the Chinese school
Vernacular
and
school.
vernacular school, which is the Chinese and the Tamil school. So we can fight them with that with that point, which is the kan boleh, tapi kita kena musnahkan sekolah Cina dan juga sekolah Tamil. Am I right?
Basically, we already have apa step to try and balance that out.
Yes.
But I feel like most of
But they
this,
still feel unfair about the hak keistimewaan orang Melayu.
Tapi I feel like most of these issues that come from the university students. Sebab most of these exceptions come in form of university. Sebab in school, walaupun okay, maybe there already has that problem already exists, tapi cuma it's not that noticeable lah. Tapi when it comes to they want to go pick a uni lah, for example, mungkin STPM is a fair choice, but what about public unis, kan? So do you guys think that's fair?
I think it's not fair because basically public uni is more cheap than the swasta. So like maybe like kesian jugalah kat yang Chinese and Indian sebab kebanyakan uni yang diorang masuk kena bayar lebih daripada orang Melayu.
Probably is fair because of course kita adalah senang cerita, kita adalah tuan rumah, kita adalah owner, which is hak kebebasan orang, hak keistimewaan orang Melayu ni. Okay, why the government buat macam tu? Because of diorang nak majukan dulu orang Melayu, the bumi putra itself before them. So for them like Chinese and Indian is bukan diorang pun tak penting, diorang penting, tapi diorang lebih mengutamakan orang Melayu untuk kemajuan orang Melayu. Sebab at the future siapa yang akan pegang kerajaan, siapa yang akan memimpin kerajaan kalau bukan kita sendiri.
I mean like kaum lain, bangsa lain, other races, they also do have their own macam privilege. Okay, it's not that they are totally out of this list ke apa. They still have fair lah. It's just that we ada prioritize more. We have more spatial
Treatment. Special
So
treatment.
basically, every single race has their own privilege, but in different parts lah. So okay, I feel like that should be enough for the limitation and exception. Unless if you guys want to add something more, which I think kita dah panjang for limitation and exception. But I also want to add my opinion on it lah. I think it's really fair sebab it's hak Melayu, it's already constitution dah kukuh. It's already discussed with dah lama dah, long time ago. The king, the kings, everybody has already decided that it's a good hak Melayu memang ada. So bumi putra already has the right. So
That was balance already.
So I guess now we will move on to the case laws. So we'll give it to the girls first, the wanita hari ini, to talk about their case. Wanita hari ini. I still can't get that right. Wanita terkini.
So our case for today is about what is it again?
So basically the case that we're going to talk about Rusia Sabderin and Muhammad Jainal Jamran, which is salah satu kes sivil yang dibawa oleh pelajar-pelajar Sekolah Menengah Kebangsaan SMK Tanggusi, Kota Belud, Sabah, towards dia punya guru, pengetua dan juga pihak berkuasa, which is the pihak pendidikan. So Putri will explain more about the brief fact.
Okay, so there was a English teacher at this school. The English teacher is basically the first defendant here, and what happened here is that she consistently absent from March to July 2017. So basically she was absent without no reason.
She?
Is it she or he?
He, Muhammad Jainal Jamran. It's okay.
I'm sorry for that. He. So he was absent without any valid leave and also reasons. So the plaintiff here sued the first defendant, which is the English teacher, obviously. And then the second defendant here is the school principal. And the third one is the Director of General Education. And the fourth one is the Minister of Education. And the fifth defendant here is the Government of Malaysia. So what the plaintiff claim here is that the breach of the statutory duty under the Education Act 1996, because he was basically absent without any reason. And also violation of their constitutional right to education under Article 5, subsection 1, with the Article 12 of the Federal Constitution. So the defendant denied the claims, arguing the teacher was present. So the principal took appropriate action, and that vicarious liability did not apply to the higher defendants. Next, about the legal issue will be explained by Dana.
So basically for the legal issue, which is untuk isu utama yang tadi putuskan oleh mahkamah, first about the first defendant failed to teach, and the second one whether the second defendant had noticed, and the third one which is whether the second defendant took reasonable step to exercise disciplinary control. Dan yang keempat, pihak defendant, yang ketiga, keempat dan juga kelima defend where the vicariously liable, and then yang kelima whether all defendants took reasonable step which is to safeguard to the plaintiff, and the last one whether the plaintiff suffered damage due to the defendant's acts. So
kita ada 5 legal issue here lah. Banyak because it involves a lot of orang panggil defendant here, because when the teacher itself absent, of course it would affect to the others, ada guru punya principal, pengetua sekolah tu, and then other governments of education and all that, right?
So dalam arti kata lain, macam mahkamah perlu nilai balik adakah tindakan pihak sekolah dan pihak berkuasa pendidikan tu berjumlah dan dia melanggar tanggungjawab undang-undang yang dah dikesan pada pihak pelajar. So basically the decision court which is pada 18 Julai 2023, Mahkamah Tinggi telah memutuskan bahawa guru, pengetua dan pihak pendidikan telah melanggar tugas mereka dengan tidak mengajar, tidak memantau dan tidak menjalankan tanggungjawab pengajaran dengan sewajarnya lah. So basically pihak kerajaan negeri dan Kementerian Pendidikan dianggap bertanggungjawab secara tidak langsung kerana mereka bertanggungjawab untuk memastikan pihak sekolah melaksanakan tugas mereka, which is di mana guru tersebut gagal untuk mengajar pelajar dan pihak pengetua gagal untuk memastikan guru tersebut menjalankan tanggungjawab je lah. So untuk hak perlembagaan pula, mahkamah mendapati tindakan mereka juga mencabuli hak perlembagaan pelajar terhadap pendidikan di bawah artikel 12 Perlembagaan Persekutuan yang menjamin hak untuk mendapatkan pendidikan. So the last one we go to
interpretations and applications of Article 12 into this case.
So that one, okay, so untuk interpretasi hak pendidikan related with this article, which is mahkamah menggunakan artikel 12 ni bukan secara sebagai janji moral tapi sebagai hak yang boleh dikuasakan secara sivil. Ini bermaksud pelajar tidak hanya mempunyai hak teoretikal untuk belajar tapi juga hak untuk mendapat pengajaran yang sebenar dan berkualiti daripada pihak sekolah yang bertanggungjawab. Dan guru dan pengetua juga mempunyai tanggungjawab untuk mengajar pelajar, memastikan penyampaian pendidikan yang minimum diterima oleh pelajar, dan yang terakhir mematuhi kod disiplin pegawai awam seperti yang termaktub. Kalau cikgu tak boleh follow the rules, the guideline, how the student pun nak follow kan. So the last one we have mahkamah menegaskan bahawa kerajaan negeri dan Kementerian Pendidikan bertanggungjawab secara bertali kait atas tindakan atau ketiada tindakan pihak sekolah kerana mempunyai kuasa kawasan terhadap sekolah awam. So ini membuka ruang kepada pegawai awam yang tidak kebal daripada undang-undang, terutamanya apabila hak pendidikan pelajar terganggu akibat kecuaian pihak sekolah. So
yeah, that's all from us.
I would like to add our case yang kita dah cari. This case is called Muhammad Adam Yusof Abdul Hafiz and Anwar versus Sekolah Menengah Pendidikan Khas Vocational Section 17 Shah Alam. Panjangnya and/ors. Panjang. Okay, so the brief story is that the brief fact lah is that the first appellant, which is the special needs student, dia suffer from ADHD, Asperger's syndrome.
I pernah tahu like if student yang ada ADHD can also claim as OKU, right? Even though it's not like physically orang panggil physically effect lah dia punya bodies and all that.
So the main point here is this special needs and dia ada physical disability. So dia masuk dekat sekolah ni yang it's a special education lah, it's a special education boarding school under Ministry of Education. And then so the
like pendidikan khas.
Yeah, pendidikan khas, it's a special school for special kids, for special needs lah. So the mak dia sama lah sekolah ni, saying that the sekolah
gagal,
committed breach of duty. Diorang breach of duty sebab diorang failed to protect anak dia against bullying and for alleged assaults. So
may I ask one question?
Yes.
Like the reason why they sue this school, right, is because the sekolah tu failed to protect, you say, right?
Yeah.
So like for how long school to fail to protect that? Is it like
pretty sure
so long it caused the mother to like?
I think we can touch on that after this, but I'm pretty sure it's quite some time lah sebab I don't think any claims like this dia akan tiba-tiba cakap dan tiba-tiba tu, so it must be built up from somewhere lah. But the going back to the main part of the case is lepas tu the respondents basically yang kena saman tu lah, or yang kena nak diambil tindakan atas kan, diambil tindakan atas, failed to provide proper special education as required under Article 12 of the Federal Constitution and Section 28 of PWDA. So I'm going to explain what PWDA is. Kau tahu tak what PWDA is?
Yeah, it's about a person with a disability.
Person with disability.
2008.
So it's basically, it states here that
It applies to any age lah.
it applies to people yang ada disabilities, like this case specifically. But walaupun they use these sections, Article 12 and PWDA, doesn't mean that this case can be accepted or is right. Sebab guess what happened at the end? Dia kena reject. Okay, first dia bawa kat high court, and then dia kena reject sekali. Okay, so dia bawa case ni dekat court of appeal, kena reject juga. Why dia kena reject? The legal issue here, yang kita cakap brief facts, so the legal issue here is whether the school breached its duty of care in negligence by failing to prevent bullying and assaults, and whether the respondents failed to provide appropriate special education yang infringe Article 12 and 28 PWDA, which is Person with Disabilities Act. Also, the other issue is whether the appellants had proven their case on a balance of probabilities, whether it's foreseeable. Basically, now, is this thing predictable from happening? So that's the issues that the court will look at lah. So the court's decision is obviously appeal dismissed by both courts. The first court, the High Court dismissed, Court of Appeal pun dismissed, affirming High Court punya decision. So why? Kenapa dia orang tolak? Why the court tolak? So although sekolah, well in this case sekolah has, but I'll just talk about sekolah in general first. School memang owe a duty of care to students, especially students in need. Yang special needs lah.
Treatment.
But the appellants failed to prove that the alleged bullying and assaults actually occurred. So they did not fail to in later stages. They already failed in the first stage, gagal dalam first fasa pertama, which is proving causation, what the cause of this. So in negligence, we learned that kena ada causation, right?
Yeah, okay.
Causation is like the main foundation of making the case itself. So that's the first part. Anak dia fail nak prove anak dia kena bully. Why diorang fail nak prove ni? So the first appellant, which is anak dia, did not testify. Maksudnya sebab anak dia kan okay,
yeah.
So dia tak boleh nak testify that these things actually happen. And second, apa yang mak dia cakap ni is mostly hearsay. Hearsay, you guys know, right? Hearsay.
Yeah, hearsay. Just
it's basically like it's just all thoughts. Basically, there's no proof, but it's all like claims. It's all claims. So in court, you can't just use claims. You mesti kena ada proof. You mesti kena ada just negligence itself. You kena ada causation, damage, and all that. And then the alleged bully was not called as a witness. The pembuli yang diorang tuduh tu pembuli is himself or themselves tak called as a witness. They're not on the court. They're not there to be called as a witness. So yang notes and journals ni pun yang written by this kid is inadmissible. Sebab yang diorang guna as yang notes ni kan as proof, it's not, they can't do that sebab there's not enough evidence in the notes itself. So the burden of proof here is under the Evidence Act 1950. The burden lay on the appellants and they failed to discharge it. So the burdens, they just failed to they failed to provide proof lah here. So education's right claim failed. The court accepted that Section 28 of the PWDA can impose duties on the state to provide appropriate special education. However, there was insufficient evidence that the school failed to provide, such as screening and categorization of students, trained and competent staff, meaning that they're saying that staff are incompetent. And the education system, the syllabus is well structured, so it does not give any unfair disadvantages to the appellant side. It's not unfair. To give a more proof of our statement, the case itself says that it's not a duty of insurance against harm, but only a duty to take reasonable care for the safety of the pupil, is what the judge said. For the first claim, which is Court of Appeal, explains why the Court of Appeal rejects. This is the reasoning. And then duty depends on foreseeability. Maksudnya kena tengok, can these things happen
in the future? Yeah.
In the future, boleh nampak these things happen. And do they also take reasonable steps? Maksudnya, do they take langkah yang untuk mencegah untuk mencegah benda ni berlaku. So the court itself says the risks of injury to the plaintiff were reasonably foreseeable, and secondly, whether the appellants took reasonable steps to protect the plaintiff. So apa maksud kat sini is strict liability does not ask whether harm was foreseeable or whether reasonable steps were taken. Negligence does, and that's the framework of the court. So kat sini, even though it's not strict liability and it's negligence, they still fail to provide the causation. So you can't even apply for negligence, kan? The last one is the court says the law does not attach strict liability on a school teacher and thus the school and education authorities for the tort of his or her pupil, but only on proof that the teacher had failed to exercise reasonable care. The teacher pun is not under strict liability for torts yang commit on the pupil, but only yang proof yang teacher tu tak ambil reasonable care lah. But here, there's not even proof that that's happening. So basically, the whole case is lack of proof. It's all lack of proof. So it can't happen. The last one is there was no breach of the requisite duty of care on the party of any of the respondents, and no question of vicarious liability therefore arose. So the assaults were not proven. So if the assaults were not proven, the court tak boleh lah nak cari fault under supervision. So reasonable measures were already in place. So everything is according lah. So that's the court's punya decision. That's what they said to make the decision to reject these cases. So that's also how the court interprets and apply the article. So basically it's saying that equal education, yes, but since this is a special school, right, for special kids, they can already assume that the school dah take respective and reasonable measurements. Tapi they still can't confirm that these kids won't do it sebab these kids kan autism, ada yang autism, ada yang memang kurang upaya, like in other ways. So you can't guarantee something for orang yang kurang upaya. So you can't guarantee what they'll do.
They're not normal.
They're not normal.
They're not having the normal behavior like others would.
They're special kids, so they would do special acts.
And they also need special needs.
They also need special needs. So that's why other special needs in school. Okay. So I guess now it's time for the conclusion, opinions and suggestions to the whole conclusion and the general conclusion.
So basically, what we can learn from this Article 12 is basically Article 12 is providing the right of education to all citizens in Malaysia, including that to like elakkan daripada discriminations and inequality. But Article 12 also have the limitation regarding to the religious educations. So I'm going to connect the Article 12 to the two cases that we already talked about. So the first case is about Rusia Sabdarin and ORS versus Muhammad Jainal Jamran and ORS. So basically in this case, there's a students that didn't like got a proper education selama 7 bulan, dan basically diorang dalam tahun tu juga untuk ingin mengambil SPM. So basically diorang telah ketinggalan dalam mata pelajaran English. So so kira diorang tak belajar dalam setahun lah. So di situ ada persoalan di mana adakah guru santri. So basically in that school diorang kekurangan guru yang mengajar English, dan guru yang patutnya mengajar diorang ada pula tidak datang, dan tidak datang tanpa memberi sebab. So basically the pengetua telah memaklumkan masalah ini ke KPM, dan sepatutnya KPM cakna dalam hal ini. Tapi kenapa KPM tak menggantikan guru, sedangkan pelepasan guru masih menganggur? Kenapa KPM tak tak serapkan ke dalam sekolah di sana? Sebab KPM tidak boleh biarkan Sabah dan Sarawak ketinggalan dalam pengajaran. Because this is one of the discrimination antara Semenanjung dan Sabah Sarawak, dan ini adalah telah melanggar Article 12 the right of education, and Article 5 the equality, Article 8 the right of equality. So in other case, for example, for the other case, the case of Muhammad Adam Yusof, Abdullah Hafiz and UMNO versus Sekolah Menengah Pendidikan KAS Vocational Section 17 Shah Alam and ORS, we all know that sekolah KAS ini adalah kes yang melibatkan sekolah KAS. We all know that pelajar-pelajar yang masuk ke dalam sekolah ini kebanyakannya ada kad OKU and yang dikeluarkan oleh Jabatan Kebajikan Kemasyarakatan JKM. So basically in this situation, the mom parents when the parents want to masukkan they have to think first, because basically in this sekolah ini mempunyai banyak pelajar-pelajar yang sangat hyperaktif, dan mereka tidak faham apa yang disuruh, seperti for example budak-budak hyper, ADHD, dyslexia, right, and OCD. So basically cikgu akan the teacher on that school will try to help the cikgu and the pembantu will help the students dekat sana.
You're saying it's
Isn't it like
so you're also saying
okay. So basically the parents need to aware that the school is not properly safe, because there's a lot of students that really not in the right mind. So that's why the High Court and Appeal Court dismissed this case, because it's not relevant, and basically the mother didn't have the enough evidence to show that the school have the negligence and negligence and bullying. So that's all for me.
So with that, I feel like we come into an end. Okay, so
ending.
I guess ending. Who wants to ending? Bye bye guys.
Thank you for listening.
Bye. From us, Musab,
Musab,
Putri, Diana, and
Asagov.
Bruno Asako.
Alright, bye bye guys. Bye.
Behind the scene.